I'm Scott Maloney, and I'm the Chief Innovator here at the Arrowhead Center. I'd like to talk a little bit about continuing your research once an intellectual property piece, either a provisional patent or a full patent, has been put in place with your technology. This is a really important topic, and I'm glad that it's a part of this ongoing series that we have here, because it attempts to answer a number of questions around what the world of research looks like when we have a patent on our technology and maybe not yet a partnership outside of the university. So let's be clear, as we talk about this particular module, we're talking about your research ongoing in your lab and doing so on a piece of patented technology that the university has now helped you secure the intellectual property rights for. We'll talk in later modules around partnerships and what those partnerships mean and how to collaborate with them as a research function. But let's just today talk about your lab, the new holders of some intellectual property filed by the university on your behalf. As you think about moving that technology forward, we've talked about the need to protect ourselves for public disclosures, and we've done that now, and our technology is well wrapped in IP, whether provisional or a full patent. What do we do with that research? Does it sit on a shelf and wait for someone to license it? Do you keep working on it and keep advancing the technology? Well, the answer in both cases, ironically, is yes in some ways. We want someone to come and license that technology. That's the best way for our technologies to live in the world and realize the full scale of becoming a product that makes someone a little happier, a little healthier, helps them save time, does something that is meaningful from a commercial standpoint. It's the reason you were looking at this discovery in the first place. So yes, we're hoping that someone comes by and plucks that off the shelf and moves that through their commercial pipeline. But what do we do in the meantime? One of the nice things about having your technology patented is it really does put the flag in the sand and says, this is my technology, and it gives you license to continue to research that technology. Now, as you're doing so and as you're advancing that technology, a couple of things need to be thought of. One, are we advancing the technology itself, the one that we have intellectual property rights for, the one that we've wrapped in that IP and we've defined properly for the USPTO? Are we advancing that technology in incremental and meaningful ways, but incremental ways forward? Or are we starting something new, starting something that's fundamentally different that cannot be interacted with or misconstrued as the first technology? That's a really important piece for us to understand. In the first case, if what we're doing is incrementally advancing that technology, then really what you want to do is stay in very close contact with Arrowhead as advisors for when we hit a point that a new technology filing might be necessary. Now, with a lot of technologies, there's what's called the obviousness portions. And the obviousness portions are simple incremental additions to that technology that any reasonable expert in the field would consider, quote, an obvious extension of that technology. These are things that you should be making. These are things that you probably are making as a researcher about your technology, advancing the topic, advancing the technology. That should not stop. It won't stop, and that's great. But Arrowhead can help you understand where the water's edge is, where such an advancement has moved to a point of really achieving something new, something novel that might require a next provisional patent, a next full utility patent, a design patent, something to further extend the portfolio of technologies. So as you're working to advance that technology, keep in close contact with Arrowhead, because we have that expertise, as do our external counsels that are all here to represent you as the PI, to help you understand where that water's edge is and make sure that your patent filings, one, remain very well intact, and two, grow with your body of research. And that also that talks about how we extend that individual technology. Now, what happens if we do get into something that's fundamentally new? Either it's a new research program, a new grant, an entirely different question or line of inquiry, or maybe it's just a very large fundamental step forward in the technology itself. I would encourage you to go back in that case and look at some of the modules around public disclosure, filing your IP, the IP process, all of these different pieces, because really what we're talking about here is the need to protect this new discovery, even if it is a big extension from the original. We want to make sure that we're being cognizant of not publicly disclosing it. We're being respectful of our collaborators, either here at New Mexico State or at other institutions. We want to make sure that we're going through that entire patent process, again, in a really programmatic and a really thoughtful way. But something else to keep in mind as we're working on our research, Now that we've covered whether or not it's an extension of the existing IP, potentially new IP, and we're building out that portfolio, we have milestones that we want to make sure that we're meeting. Like anything else, technology grows, it evolves, it changes. Your research program won't stop simply because the USPTO issues a patent, and it shouldn't. So what do we do going forward thinking about those milestones? Well, there's internal and external milestones. Internal milestones are ones you place on yourself. Your research program moves forward. You know where you want it to go. You know what it needs to achieve from a technology standpoint. And remember, we're speaking about this in the absence thus far of a partner. In other modules, we'll talk about partner interactions and what that means to really couple with industry over your IP. But before that, certainly there's internal milestones that move us forward, but there's also external milestones, and we want to be very aware of these. And these come from the USPTO. There's maintenance and upkeep costs on any patent. Now, these are not large sums of money per se, but they are regular and they are required. So as you're going through the patent process, be aware that there will be new requirements, at least with respect to filing around that IP. Now, this is something, again, Arrowhead is here for. We are your advocates as this moves forward. We are meant to help you with these filings, assist in these filings, and work directly with legal counsel to issue these filings. But nonetheless, they will require on your part random updates, not random updates, scheduled updates, and everything in between. And again, Arrowhead can be your guide in this process. So while the milestones may not be strenuous and they may not be large milestones, it is important to bear in mind that you will have requirements to maintain that patent. And therein lies kind of the rub of intellectual property. You've certainly done what a piece of IP is meant to do, created exclusion in the market for you to operate. But that exclusion requires maintenance, requires care and feeding, and we're going to make sure that you're able to do that and really help you with that process.